Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw. We bring to you the latest and in-depth legal coverage, coming to you with a brief of what all happened in the Indian courts today. Starting with the Collegium recommendations to the vacancies at the Supreme Court. The Supreme Court Collegium headed by CJI Chandrachud has passed a resolution recommending names for the two vacancies of judges in the Supreme Court. These are Justice Prashant Kumar Mishra, Chief Justice of Andhra Pradesh High Court and Senior Advocate KV Viswanathan. Justice Prashant Kumar Mishra has served as a judge of the High Court for over 13 years and ranks at serial number 21 in the All India Seniority List of Judges of the High Courts. Also, giving regard to the fact that at present there is only one member from the bar directly appointed to the Supreme Court bench, the Collegium has considered the name of Senior Advocate KV Viswanathan suitable for being appointed as a judge of the Supreme Court. According to the Collegium, the appointment of Mr. KV Viswanathan will enhance the representation to the bar in the composition of the Supreme Court. As you already know that the Supreme Court of India has a sanctioned strength of 34 judges and is presently functioning with 32 judges. With 4 more vacancies which are going to arise by the second week of July, the working strength of judges will come down to 28. Coming to an important update from the Supreme Court, which today allowed a batch of appeals against an order of Madras High Court ordering a fresh inquiry into the cash for jobs scam in which the Tamil Nadu minister and DMK MLA Senthil Balaji has been accused of accepting bribes from job aspirants. The top court also set aside a direction of the Madras High Court which stayed the proceedings in the money laundering case lodged by the Enforcement Directorate. Between 2014 and 2015, recruitment for the post of reserve crew drivers, crew conductors, junior assistant, junior engineers, etc. was conducted in all the transport corporations in the state of Tamil Nadu. It has been alleged that in these appointments, various officials of the Transport Department colluded jointly and severally, including the then Electricity Minister Senthil Balaji in the AIADMK-led regime. Let me tell you here that currently Balaji holds among others the electricity and prohibition and excise portfolios in the Tamil Nadu cabinet as a minister of Tamil Nadu's ruling DMK party. A batch of appeals that were disposed of by the Apex Court today was preferred against various orders of the Madras High Court. The Supreme Court has thus allowed the Enforcement Directorate to probe into the cash for jobs scam against the Tamil Nadu minister. The Supreme Court today adjourned to July the petition filed by former Maharashtra Minister Nawab Malik, who has been in jail since February last year following his arrest in a money laundering case by the Directorate of Enforcement. The background, as you know, is that the ED arrested Malik in February last year, alleging that he usurped a property in Kurla, Mumbai, with the help of global terrorist Dawood Ibrahim's late sister Hasina Parker between 1999 and 2006. It is the agency's case that since Parker handled the gangsters' illegal businesses, the money was ultimately used for terror funding. In November last year, the special court refused him bail, after which he approached the High Court. In February, the Bombay High Court sought to know how bail can be granted despite Section 45 of the Prevention of Money Laundering Act, which provides for stringent conditions to grant bail to accused in money laundering cases. Earlier this month, Bombay High Court had adjourned the matter to June due to non-availability of the Additional Solicitor General. Aggrieved with this, Malik approached the Supreme Court. Observing that the High Court cannot be bypassed, the Supreme Court today adjourned Malik's petition. While doing so, the bench comprising Justices Sanjeev Khanna and M.M. Sundaresh stated that the High Court will be at liberty to take up the matter in the meantime. And now coming to the Adani Hindenburg issue. The Supreme Court has adjourned to July the application filed by the Securities and Exchange Board of India, SEBI, seeking 6 months more time to complete its probe into allegations made by US-based short seller firm Hindenburg Research against Adani Group companies about stock price manipulations. although the bench had said on May 12th that it will hear the matter on 15th of May after considering the report of the expert committee led by ex-Judge Justice A.M. Sapre. The matter could not be taken up yesterday. It will now be heard on July 10th. Stay tuned with us for further developments. As you know that this is the last week of Supreme Court's working before the summer vacations begin, CJI D.Y. Chandrachud has informed the lawyers that the vacation benches will be taking up fresh admission matters and hybrid hearings will be permitted before the vacation benches for the convenience of the parties. As per the CJI, more than 300 fresh matters which could not have been taken up by the court will be listed before the vacation benches of the Supreme Court during the summer break. The summer vacation for the Apex Court is commencing from 22nd of May to July 2nd. To know more about the constitution of the vacation benches, you can click the link given in the description box below. In another update, a plea has been filed in the Kerala High Court challenging the blocking of free and open source software FOSS applications named Element and Briar by the central government under Section 69A of the Information Technology Act. As per media reports, on May 1st this year, Centre blocked 14 mobile messaging applications under Section 69A of the IT Act on grounds of such applications allegedly being used for communication between bad actors in Jammu and Kashmir. The single-judge bench of Justice Shobha Annamma today issued notice to the Ministry of Information and Broadcasting and the Ministry of Electronics and Information Technology. According to the plea moved by the aggrieved software developers belonging to the FOSS community of India, the impugned order issued by the central government is liable to be set aside for placing unreasonable restrictions on the exercise of freedom of speech and expression, as well as for carrying out trade and business as enshrined in the Indian Constitution. The matter has been posted for further consideration on May 29th. Lastly, coming to the new update on the controversial film The Kerala Story. A public interest litigation plea has been moved before the Calcutta High Court challenging the West Bengal government's ban on the screening of the movie, stating that the movie raises the issue of love jihad, and in a democracy like ours, public discussion on a subject like that is necessary. The PIL filed by Devdatta Maji and Surman Ali Mandal states that the order of the government of West Bengal prohibiting the exhibition of the film in the entire state is against the West Bengal Cinemas Regulation Act. The PIL plea further states that once the Central Board of Film Certification has granted certification to the film, non-exhibition of the same by state infringes the fundamental rights of the contesting parties like the petitioners. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can check the links given in the description box below. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us.